Federal Power of Nigeria that Petitions applied. I've studied the case thought to be relied on as acceptable in this case. It's apparent that the parties in that case are not the same as in the instant petition. The issues, though the same, were not resolved to finality in the previous case. The action was struck out on ground of lack of local standard by the lower court, which this court affirmed on appeal. Thus, the objection on that ground is also discontinued. On whether the question is started back, I had held in the earlier motion filed by the first respondent on 7th May 2023 and third fourth respondent's motion filed on 12th May 2023, which were taken together. This petition, which is premised on the nomination of sponsorship of the fourth respondent, is a pre-election matter. That being a pre-election matter, it ought to have been imputed and ventilated by the petitioner before the Federal High Court within 14 days from the date of occurrence of the event. Or action on 7/5/23 and 12/5/23 that issues of nomination or sponsorship were candidated by political parties for an election come under pre-election matters. It is settled that the issue of nomination of candidates by succession is purely a pre-election matter. The only person with the local standing to challenge the nomination is an aspirant who participated in the process of such nomination. In other words, apart from an aspirant who took part in the primary election, no other person is authorized to challenge such nomination under pre-election matter to an election. Settled that process of challenging the nomination is sanctioned by Section 84 of the election matter. The only person with the local standing to challenge the nomination is an aspirant who participated in the process of such nomination. In other words, apart from an aspirant who took part in the primary election, no other person and another authorized Aziz Ayari and challenge that another election matter. Therefore follows that the process of nomination, which is rooted in the nomination or sponsor of the fourth respondent, is a pre-election matter. Being a pre-election matter, the petitioner herein has no local standing to challenge or question such nomination or sponsorship of the fourth respondent by the second respondent. Thus, in People's Democratic Party (PDP) and Independent National Electoral Commission and others, unreported decision of the Supreme Court delivered on 26th day of May 2023 in SC CV 501/2023. I had the matter has been reported, but I have not been able to avail myself of the report. Held at the Supreme Court held at page 71 page 31 lines 1 to 16 thereof as follows. Court, the provision does not make the filing of pre-election matters by political parties an all-comers affair. It is not the purpose of the provision that the floodgate of pre-election litigation be open to political parties who will hide under it to challenge the actions or inactions of rival political parties under the guise of challenging the decision or activities of INEC. The application of Section 285, Section 14C of the Constitution does not extend to a political party poking into the affairs of another. The position of the law has always been that no political party can challenge the nomination of the candidate of another political party, no matter how pained or disgruntled a political party is with the way and manner another political party is conducting or has conducted its affairs concerning its nomination of its candidates for any position. It must keep mum and remain an onlooker, for it lacks the local standing to challenge such nomination in court. Close of court. It is clear, therefore, that a political party such as the petitioner herein only has the local standing to file a pre-election matter when the situation affects it or its candidate by virtue of Section 285, Section 14C of the 1999 Constitution. That being so, as in the instant petition, where the grounds of the petition is rooted on the nomination or sponsorship of the candidate of another political party, this petitioner will have no local standing to institute the action, be it in the Federal High Court or an election tribunal. For that reason, it is my view that the course of action in this petition being on the nomination and sponsorship of the third and fourth respondent by the second respondent applicant, petition is incompetent for lack of local standing on the petition to institute the action. also liable to be struck out for being incompetent. The second respondent applicant also contended that the petition is not properly constituted as the candidate sponsored by the petitioner has not been joined as co-petitioner in the petition. The short answer to that is that Section 133, Subsection 1B of the Electoral Act 2022 entitles a petition as a political party to institute an election petition. The applicant has not referred us to any provision of the Electoral Act or any authority that mandates the political party to file an election petition only when its candidate has been joined as a co-petitioner. It is true that it is proper for the candidate of the party to be so joined, but there is no law that compels the political party to join its candidates in the petition. After all, the purpose of such joinder is so that the candidate can be bound by any judgment or order of the court or tribunal, but any non-joinder would not invalidate the petition. This is particularly so when Section 133, Subsection 1 of the Electoral Act stipulates as follows. An election petition may be presented by one or more of the following persons: A, a candidate in an election, or B, a political party which participated in the election. By the use of the disjunctive word "or," it means that an election petition may be filed by the candidate alone, or the political party alone, or both of them. The objection on this ground is also discontinued. By another motion filed on the 15th of May 2023, the fifth respondent, thus Kabir Masari, prayed this court to grant him the following reliefs. 1. An order of district court dismissing this petition in its entirety for one of jurisdiction. 2. An order striking out the name of the fifth respondent applicant from this petition for non-disclosure of any reasonable course of action against him. And 5 other orders as this honorable court may deem fit to make in the circumstances. The grounds for the application have been stated. I've also considered the submissions of counsel. Now, Section 133. Section 133 of the Electoral Act defines persons who are necessary parties in an election petition. Generally, necessary respondents in an election petition are the persons whose election or return is complained of and the electoral body that conducted the election. See Section 133, subsection 2 and 3 of the Electoral Act 2022. Those are what are termed statutory respondents. It should be remembered that election petitions are sui generis, and its procedure is strictly regulated by statute. That's why a person does not fall within the category of statutory respondent. They are not necessary parties in an election petition. See the cases of Agbere and Nimra, Buhari and Yusuf, APC and PDP. That's in Waziri versus Gaidam. The Supreme Court held a court. From the above, I have no difficulty in going along with the submissions of the respective counsel for the respondent that Section 137, sub 2 and 3 of the Electoral 2020 has no room for the joinder of the fifth respondent who neither won the election nor performed any role as electoral officer or agent of the third respondent in the election petition, challenging the result of such an election. And even no relief was claimed against the said fifth respondent, and indeed, he had nothing to gain or lose in the petition after the close of court. Indeed, a holistic reading of the facts of this petition does not disclose any complaint against the fifth respondent. The only fact that relates to the fifth respondent relevant to the petition is the act of withdrawal of his candidacy as the running mate of the third respondent. That is an act that occurred within the election period, therefore cannot amount to any act done by the fifth respondent at the election. It cannot therefore ground any complaint by the petitioner against the fifth respondent in an election petition. It may be relevant in a pre-election matter, but not in an election petition. It is therefore my finding that there is no any claim on the fifth respondent. In other words, the relief sought in the petition will not in any way affect the citizen respondent, as he did not participate in the petition either as a candidate or agent of the second respondent, and no declaration was made in his favor by the first respondent. In that respect, I hold that the objection of the first respondent on this ground has merit. Accordingly, I order that the name of the citizen respondent be struck out of this petition. These are the rulings in respect of the petition number 4. I will now go to the main petition itself. So, after the pre-hearing session, hearing on the petition opened and closed on the 21st of June 2023, the petitioner called one witness and closed his case. None of the respondents called any witness, but tendered some documents from the bar, and the petition was adjourned for adoption of written addresses. Parties then filed on self-written addresses as directed by this court, and same were adopted on the 14th of July 2023. The matter was then adjourned for judgment. The first respondent's written address was filed on the 30th of June 2023. Therein, 4 issues were raised for determination as follows. 1. Whether considering the facts of the petition and evidence laid thereon, the petitioner has the lawful standing to question the nomination of the first respondent as a ground of challenging the qualification and stand of the third respondent as the winner of the presidential election of 26 February 2023. 2. Whether having regard to the facts pleaded and evidence laid thereon, vis-a-vis the provision of Section 134, Subsection 3 of the Electoral Act 2022, can the issue of validity of the nomination of the first respondent as the vice president candidate of second respondent be validly raised as a ground before this honorable court to question or challenge the qualification and return of the third respondent as the winner of the presidential election of 26 February 2023. Number 3, if the answer to note 2 is in the affirmative, whether having regard to the facts pleaded, the nomination of the first respondent as the vice president candidate of the second respondent is void, as to render the third respondent not qualified to contest the presidential election of 26 February 2023. 4. Whether considering the relief sought as per the petition accrues no utilitarian benefit to the petitioner, this petition not an abuse of court process. Well, to save time, all the other respondents filed briefs and raised issues. These issues have been introduced in this judgment, including the issues raised by the petitioner. It is apparent from the averments in the petition, the oral and documentary evidence, and the submissions of counsel that this petition is grounded on the disqualification of the third respondent to have contested the presidential election of 26 February 2023. This is evident in paragraph 15 of the petition, wherein the petitioner pleaded thus. I had read it earlier. This is further explained as emanating from the non-qualification of the first respondent to have contested the election as the vice president candidate of the second respondent. It is specifically pleaded in paragraph 17 of the petition as follows. Your petitioner states that the first respondent was not qualified to jointly contest with the third respondent for the presidential election held on 26 February 2023, having been purportedly nominated by the second respondent as its candidate for more than one office. The specific reasons for questioning the qualification of the third respondent have been pleaded in paragraphs 16.1 and 2 of the petition as follows. Those paragraphs have been reproduced. If you get the judgment, you will see it there. So a combined reading of paragraphs 16, 16, and 17 of the petition, coupled with the particulars thereof, show clearly that the petition is premised on non-qualification of the fourth respondent. I find it necessary to state that the grounds for questioning the return at an election are stipulated in Section 135 of Section 1 of the Electoral Act that has been produced earlier. It is the ground stipulated in Section 134(1)(a). That they are not qualified to have contested the said presidential election. I consider paragraphs 18, 19, 20, 21, 22, 23, 24, 26, and 20 of the election as relevant for the termination of the petitions, which paragraphs have been reproduced in this judgment. In response, the first respondent, that's INEC, filed a reply to the petition where it was averred in paragraphs 14, 15, and 16 of the first respondent reply to the petition as follows, which has also been reproduced. The second respondent also filed a second respondent reply to the petition and also made their own averments in paragraphs 16, 17, 18, 19, 20, 21, 22, 23, 24, 25, 26, and 25, 29, which have been produced herein. So from the totality of the pleadings in the petition and the replies of the respondents, what appears from the complaint of the petitioner is that the fourth respondent, while still a candidate of the second respondent for Borno's Central Senatorial District, was nominated and did accept to be the vice president candidate of the second respondent. That this act violated the provision of Section 35 of the Electoral Act 2022 as it amounted to his double nomination. That in the circumstances, his nomination as an associate of the second respondent for the presidential election is void. That the result is that the third respondent was disqualified from contesting the election because he did not have a validly nominated running mate at the time of the election. The petitioner relied on Section 131 and 142(1) of the 1999 Constitution for his postulation. Section 131 and 142 sub 1 of the Constitution of Federal Republic of Nigeria as amended stipulate as follows. A person shall be qualified for election to the office of president if A, he is a citizen of Nigeria by birth, B, he has attained the age of 40 years, C, he is a member of a political party and is sponsored by that political party, and D, he has been educated up to at least school certificate level or its equivalent. 142(1). In any election to which the foregoing provision of this part of this chapter relate, a candidate for an election to the office of president shall not be deemed to be validly nominated unless he nominates another candidate as his associate from the same political party for his running mate for the office of president, who is to occupy the office of vice president, and that candidate shall be deemed to have been duly elected to the office of vice president if the candidate is for election to the office of president who nominated him as such associate is duly elected as president in accordance with the provisions aforesaid. The general principles of interpretation of the Constitution, which is the supreme law of the land, is that mere technical rules of interpretation of statutes are to some extent be avoided in a way as not to defeat the principles of government. Thus, where the words used are clear and unambiguous, a literal interpretation should be applied. In the interpretation, therefore, the provisions of the Constitution are to be accorded holistic interpretation so as to avoid ambiguity and arrive at the true intention of the legislature. The court must limit itself to the words used in the Constitution without resort to any external aid or materials. See the cases of Sani and President Federal Republic of Nigeria, Amadi and INEC, and Agi and PDP and others. Thus, in Wike Ezonwo Nwesom, Honorable Dr. Dakuku, Adol, Peterside, and others, the Supreme Court observed that, I quote, the principle of conception of the Constitution to the effect that a Constitution is a living document, not just a statute, providing a framework for the governance of a country, not only for the present, but for generations yet unborn. It was held that in construing the Constitution, undue regard must not be paid to merely technical rules, because in doing so, the objects of the provisions as well as the intention of the framers of the Constitution will be frustrated. Courts have always been encouraged to adopt a broad and liberal spirit in interpreting the provisions of the Constitution, while constantly bearing in mind the object which such provisions were made to serve, close of court. That being so, where the Constitution has stipulated the qualifications to be attained by a person contesting or seeking to contest for any elective office created by the Constitution, the courts cannot create or import into the Constitution any other qualifying or disqualifying factor. This has been the position of the Supreme Court and dutifully followed by this court. It has therefore been held that qualification or disqualification of candidates to contest election is exclusively determined within the context or scope of the Constitution, and that nothing can be added to it. In other words, the Constitution, being the ground norm, is superior to any other law, including the Electoral Act. Therefore, where the Constitution has qualified a person or candidate to contest an election, no other law except the Constitution itself can disqualify him. The petitioner, in this case, has premised his complaint of non-qualification or disqualification of the third and fourth respondents as the president and vice presidential candidates of the second respondent on the issue of invalid nomination of the fourth respondent. That the fourth respondent, while still the senatorial candidate of the second respondent for the Borno Central District, allows himself to be nominated as the vice presidential candidate of the second respondent for the same election. In our rulings earlier delivered on the motions and preliminary objections, we had ruled that the petition grounded solely on the issue of invalid nomination or improper nomination is not a cognizable ground of disqualification under the Constitution. In other words, the claim in the petition that the third respondent was not qualified to contest the presidential election because he nominated an associate whose nomination was invalid does not flow from any ground of disqualification of a candidate to the office of president as stipulated in section 131 and 137 of the 1999 Constitution. See the cases of Balewa and Muazu, and Faleke and Ainik, Tazu versus Yerwa. Then in Shinkafi versus Yari, the Supreme Court held that the Supreme Court has listed in section 182, section 182 very exhaustively all the issues that can qualify a person from contesting the office of governor of a state. From the record of this court, the facts have not disclosed any evidence to show that the first respondent was not qualified to contest elections into the office of governor of Zamfara State. It is my view that once a candidate sponsored by his political party has satisfied the provisions set out in Section 177 of the Constitution and is not disqualified under Section 182 subsection 1 thereof, he is qualified to stand election to the office of governor of a state. No other law can disqualify him. This authority can apply mutandis to Section 131 and 137 of the Electoral Act. It has not been contended by the petitioner that either the third or fourth respondent is trammeled by the provisions of Section 131 or 137 of the 1999 Constitution. The complaint of the petitioner rooted on nomination and suspension of third and fourth respondent will find accommodation in a pre-election dispute, which the petitioner cannot even pursue, not being a member of the second respondent. This Section 84, subsection 14 of the Electoral Act 2022 and 285(14) of the Constitution. While I'm tempted to put an end to this petition at this stage, but realizing that this court is not the final court on the matter, I'm constrained to look at the merit of the petition. As pointed out, the complaint of the petitioner in this petition is that the third respondent was at the time of the presidential election held not qualified to contest the election. This is because, according to the petitioner, the fourth respondent was not qualified to run on a joint ticket with him, that third respondent, as the fourth respondent nomination was invalid for double nomination, which violates Section 35 of the Electoral Act 2022. As stated earlier, the petition contended that the fourth respondent was a candidate of the second respondent for the Borno Central District when the third respondent nominated him as his vice presidential candidate on the 14th July 2022. In other words, that at the time the fourth respondent was nominated, he had accepted nomination as the vice presidential candidate of the second respondent. He was still a validly nominated central candidate of the second respondent for Borno Central District. The petitioner then contended that the second respondent had earlier submitted the name of the third respondent together with that of the fifth respondent to ANIC as his presidential and vice presidential candidates for the 25th February 2023 election. However, that before the date of the election, the fifth respondent withdrew his candidature as the running mate of the third respondent on the 24th June 2023, and the name of the fourth respondent was then submitted to ANIC, that's first respondent, on the 15th July 2022. That the second respondent did not conduct any fresh primary election for the purpose of picking another running mate for the third respondent after the withdrawal of the fifth respondent. The respondents conceded that the fourth respondent was ab initio the central candidate of second respondent for Borno Central District. However, that on the 6th July 2022, the fourth respondent, via a letter dated the same date, notified his political party, that second respondent, of his withdrawal from the central candidature. That upon receipt of the fourth respondent letter, the second respondent immediately notified ANIC, and which notification letter was received on the 13th July 2022. That the said letter also notified the first respondent of its intention to conduct a fresh primary election for the replacement of the first respondent following his withdrawal as a central candidate. That it was until 14th July 2022 that the first respondent was nominated as the third respondent associate for the presidential election of 25th February 2023. The fifth respondent notice of withdrawal as a candidate is in evidence as Exhibit PA2, while the notice of withdrawal and letter of voluntary withdrawal of the fourth respondent are in evidence as Exhibits PA3 and PA4 respectively. It will appear that the petitioner is the view that the fourth respondent was still the central candidate of the second respondent as at the 14th of July 2022, when the fourth respondent was nominated as the vice presidential candidate of the second respondent. However, the respondent contended that the issue of alleged double nomination of the fourth respondent has been determined finally by the Supreme Court in People's Democratic Party, PDP versus ANIC, that in the circumstances, the said judgment of the Supreme Court constitute estoppel parem judicata and binding on the parties to this in this petition. Now, for a judgment to constitute issue estoppel, the conditions I had earlier stated in the rulings. So the three elements must be present and coexist for a plea of estoppel parem judicata to apply. See the cases of Ito and Epe and others, Oshoboja versus Amida and others, and Alexandra and others versus Lone Star Drilling Company Limited, all citation supply. It is obvious that the judgment sought to be relied on for the plea of estoppel is that of the Supreme Court, the highest and final court in this country. There is no doubt that the decision was final, and the issue that was determined by the Supreme Court is the same as in the present petition, with whether the fourth respondent breached Section 35 of the Electoral Act but by allowing himself to be nominated in more than one constituency. The petitioner has, however, argued that the issue decided by the Supreme Court was merely on the local standing of the PDP to question the nomination of the fourth respondent, the candidate of the APC, a different political party. That may well be so, but it is clear from the judgment, that's Exhibit X1, that the Supreme Court pronounced on the substantive issue of double nomination. Though Joro JSC, who delivered the lead judgment, declined to exercise the powers of the Supreme Court under Section 22 of the Supreme Court Act to pronounce on the merit of the case, the other laws of the Supreme Court proceeded to do so. It is settled law that a contributory or concurrent judgment has equal weight as the lead judgment. It is part of the lead judgment and therefore has the same force and binding effect. The mere fact that a concurring or contributed judgment contains what is not in the lead judgment will not whittle down its binding effect. Thus, in Olu Fairbar and others versus Abdurrahim, my Lord Fabi JSC said, I quote, a concurrent judgment has equal weight with or as a lead judgment. A concurrent judgment complements, edifies, and adds to the lead judgment when the justice adds to it certain fact aspects which the writer of the lead judgment did not remember to deal with. Insofar as a concurrent judgment performs same or all the above functions, it has equal force with or as the lead judgment, insofar as the principles of cetare decisis are concerned. Now, it is apparent that the parties in Exhibit X1, PDP and ANIC, and other supra are not the same as in the present petition. The earlier decision, though, involved the first, second, and fourth respondents. The present petitioner was not a party in that case. That is why it was argued by the petitioner herein that Exhibit X1 cannot operate as to stop it from litigating the issue of dominant nomination of the fourth respondent. The respondents have responded that the judgment in PDP and Annex Exhibit X1 is a judgment in rem as opposed to judgment in personam. In law, a judgment in personam is a judgment against persons who are parties or privy to the particular suit or proceeding alone. It is referred to as judgment inter partes. It is a judgment binding on the parties to the action alone. A judgment in rem, on the other hand, is a judgment that determines the status of a person or thing as distinct from the particular interest of a party to the litigation. It is referred to as judgment contra mundum, binding on the whole world. It is therefore binding not only on the parties to the dispute, but even non-parties. Therefore, once the status of a person or thing has been pronounced upon by a court of competent jurisdiction, no person is permitted to assert the contrary of what the court has decided. See Black's Law Dictionary, 11th edition, Adadi Jobi and others versus Oguntayo and others, citation supplied. It is no doubt that the judgment matter in PDP and INEC others X1 was in respect of the alleged double nomination of the first respondent as the vice president candidate of the second respondent in the 25th February 2023 presidential election. That is the same issue raised in this petition, as grounding the disqualification of the third and fourth respondent in this petition. Pronouncing on the issue in this case, in the contributory judgment, my Lord Okoro JSC, who presided on the panel of the Supreme Court, held as follows, I quote, there is no doubt that the fourth respondent was at a stage nominated as a candidate representing Borno Central District, but upon being muted, he would pair with the third respondent as vice presidential candidate of second respondent, All Progressive Congress, APC, in the 25th February 2023 general election. He withdrew his candidature for the Senate before taking up the position of vice president candidate. Documents in the record attest to this fact. These are APC 1, APC 2, which were made on the 6th and 10th of July 2022, respectively, laws of court. After considering those documents, His Lordship concluded at page 7 of the control judgment that, quote, it is crystal clear that the two exhibits alluded to above, the fourth respondent did the needful by resigning his position of Senate candidate for Borno Central District since 6 July 2022, before being nominated by the third respondent to run alongside him as vice presidential candidate of All Progressive Congress, close of court. My Lord Okoro went on to, after citing Section 31 of the Electoral Act 2022, held at page 8 of his contributory judgment that I quote, the above provision of the Electoral Act 2022 was duly complied with by the respondent. It is my well-considered opinion that as at the 6th of July 2022, having withdrawn his nomination and personally served him on the second respondent of the withdrawal of nomination on 6 July 2022, the fourth respondent was no longer a candidate for the Borno Central District elections, and his subsequent nomination as vice presidential candidate of the second respondent for the presidential election was not multiple nomination, as there was no longer a nomination for the fourth respondent since his withdrawal on the 6th of July 2022. I have also cited the elaborate contribution of His Lordship, Ajim JSC. It's a bit lengthy, so So I have endeavored to quote extensively the dicta of the laws of the Supreme Court in PDP and INEC Supra in order to show that the issue of double or even multiple nomination of the fourth respondent as the central candidate and vice presidential candidate of second respondent in the 25th February 2022 general election has been settled to finality. It is a judgment in rem, therefore binding on the parties to this petition and in fact the entire world, including this court. Being the judgment of the final court of the land, of this land, this Supreme Court, no person is permitted to again raise and litigate on it in any other action or proceeding. It is therefore settled and remains settled that this petition, which questions the qualifications and seeks to disqualify the third and fourth respondents from contesting and occupying the seat of President and Vice President of Nigeria on ground of double or multiple nomination of the first respondent and Vice President candidate of the second respondent on ground of double or multiple nomination of fourth respondent has no substance. I only wish to add that Section 35 of the Electoral Act is targeted at the candidate and not the political party. That is why it uses the terms a candidate and normally allows himself to be nominated by more than one political party or more than one constituency. Thus, to prove that a candidate knowingly allows himself to be so nominated, both the intent and actual acts of nomination, that is, the mens rea and actus reus of the act prohibited, must be proved, the stipulation in the section being a penal provision. In the instant case, neither the intent nor the fact of the first respondent to allow himself to be so nominated was established. That's why His Lordship Ogumi JSC, in his contributory judgment in Exhibit X1, held as follows, I quote, by Section 31 of the Electoral Act, the fourth respondent, Shetima, was obliged to submit a notice of withdrawal in writing to his party, which he did, and then his party is to deliver that notice to the Commission not later than 90 days to the election. In view of the above stated position of the law on this issue and the facts of this case, there exists no animus or display of intention by the fourth respondent to stand as the nominated candidate of the second respondent for the vice presidential position and also the senator representing Borno Central District in the general election of 25 February 2023. There cannot be any other interpretation in the circumstances unless there is clear intention to knowingly stand as a candidate for two elective posts in the same election cycle. Jim JSC also contributed as follows. Quote, the manifest intention to relinquish the earlier nomination to pave way for the nomination of another person to replace him as the party's central candidate cannot be overlooked or disregarded. To simply isolate the assumed or purported short-lived coexistence of the two nominations for treatment as multiple nomination without regard to the obvious intention of the first respondent not to be the party's candidate in elections in two constituencies is against the legislative intent of Section 35 of the Electoral Act 2022. The sequence of the occurrence of the events is not what determines the existence of multiple nomination. It is the intention, design, or purpose to hold two or more nominations as candidate for election that shows that the person so nominated knowingly did so. The second respondent did not intend that the first respondent should be its candidate for Borno Central election and its vice presidential candidate for the presidential election, and the first respondent did not understand or know that he was so nominated. The word knowingly in Section 35 of the Electoral Act must be interpreted broadly to include all its literal meanings. Barton's Legal Thesaurus, 4th edition by William C. Barton at page 356. It is defined to include advisedly, deliberately, designedly, intentionally, learnedly, pointedly, purposefully, with knowledge, etc. It is clear to me, therefore, that from the oral and documentary evidence adduced by the parties on this petition, the intention and fact of knowingly allowing himself to be nominated in more than one constituency as alleged by the petitioner against the first respondent has not been established. In other words, both the mens rea and actus reus of the act prohibited by Section 35 of the Electoral Act 2020 were not established. One other aspect alleged by the petitioner on his claim of invalid nomination of the third and fourth respondent is that the second respondent did not comply with Section 33 of the Electoral Act in the nomination of the first respondent as vice presidential candidate, that after the withdrawal of the fifth respondent, the second respondent should have conducted a fresh primary election within 14 days for the purpose of nominating a new vice presidential candidate. Now, Section 33 of the Electoral Act stipulates that a political party shall not be allowed to change or substitute its candidate whose name has been submitted under Section 29 of this Act, except in the case of death or withdrawal by a candidate, provided that in the case of such withdrawal or death of a candidate, the political party affected shall, within 14 days of the occurrence of the event, hold a fresh primary election to produce and submit a fresh candidate to the Commission for the election concerned. The interpretation of this provision does not, in my view, cause any difficulty as to require the application of any technical rule of construction. Therefore, a literal interpretation will suffice. It therefore means that where a political party has submitted the name of a candidate pursuant to Section 29 of the Electoral Act supra, it cannot be allowed to substitute or change that candidate except in the event of death or withdrawal of such candidate. By the proviso thereto, the political party affected is enjoined to conduct a fresh primary election for the purpose of producing a new or fresh candidate to submit to the Electoral Commission. The grounds of the petitioner here is that the fifth respondent withdrew his nomination as vice presidential candidate of the second respondent, but the second respondent did not conduct another primary election for the purpose of producing a new vice presidential candidate within the 14 days prescribed by Section 33 of the Electoral Act. It should be remembered that by Section 142, subsection 1 of the 1999 Constitution, a presidential candidate for election to the office of president has the sole discretion, authority, or power of nominating his associate who shall run with him in the election as vice president. The choice or nomination of vice presidential candidate is not the product of any primary election. Therefore, in my view, the requirement to conduct a fresh primary election does not apply to the nomination of a vice presidential candidate. Thus, my Lord of GJC highlighted this point in Exhibit X1 as follows. The fourth respondent was not required to buy any nomination form. He was the second respondent, APC's candidate at the election into the office of Senator representing Borno Central Senatorial District. But before the election could hold, he was nominated as the third respondent's associate, who is to occupy the office of vice president. The fourth respondent did not buy a nomination form for the said office, and most importantly, did not contest any primary election in order to emerge as APC's vice president candidate. Close of court. The petitioner in paragraph 28(2) of his petition had averred and also contended in his final address that there was a gap of about 3 weeks between the period the fifth respondent expressed his intention to withdraw and his actual withdrawal or purported nomination, thereby invalidating the nomination of third respondent because the candidature of the third respondent had lapsed and was no longer in a position to constitutionally nominate a running mate. This contention of the petition is, however, misconceived. There is nothing in the Constitution which robs a presidential candidate of his right to nominate his associate, who shall be his running mate for the office of president. There is also nothing that invalidates the nomination of a new associate by a presidential candidate as his running mate after the withdrawal of a previous associate, so long as the nomination of the new associate was submitted to the first respondent 90 days before the election as mandated by Section 31 of the Electoral Act 2022. This contention of the petitioner is therefore discountenanced. It is therefore my view that, that the position of a person as vice presidential candidate not being subject to primary election, the provision of Section 33 of the Electoral Act 2022 would not apply. On that note, I hereby hold that the petitioner failed to prove the lone ground of his petition to the effect that the third and fourth respondents were not qualified to contest the election held on 25th February 2023 for the reason of double nomination. Having resolved the sole issue of this petition against the petitioner, this position is held to be devoid of any merit. We'll rise for just 15 minutes and continue with petition number 3 and 5. I can see Dr. Levy moving up and down. So, as elderly person, I know what is going on. Yes.
We just wonder, my Lord, if your brethren agree with your judgments or not.
is the network service of the Nigerian Television Authority, and you're watching the special coverage of the sitting of the Presidential Election Petition Court, which today, Wednesday, the 6th of September 2023, is delivering its judgment in the consolidated petitions arising from the conduct of the presidential election on the 25th of February 2023. The court rose a while ago for a 15-minute break, and you heard His Lordship tease one of the attendees at the court that the court needed to give him some breather as well. So, in the interval, we'll come back to our two guests in the studios here who have been following the proceedings, especially since Judge Samani began delivering his judgment on behalf of the Court of Appeal. But of course, it's a 5-man panel, which means that the other 4 justices will also have the opportunity of delivering their own decisions. With what we don't know at the moment, and you heard that question if you've been following the transmission, popped up to the effect that was this a unanimous decision? Was this a split decision? And therefore, if it was a late judgment that His Lordship was reading. And His Lordship's response was that the 4 brother justices who are sitting on this petition will equally deliver theirs. So perhaps that's when we'll have a clearer idea whether it's a split or a unanimous decision. So back to the studios here, Ezenwa Wango and Professor Edoba Amorige, you followed the proceedings so far. It looks like we are in for a long day.
So it appears, now that we have heard from one of the justices, and we have 4 more to go. If we go by the length of the first decision, then of course we really have a long way to go. But nevertheless, we now have an idea of what the Islami is thinking, or his verdict is concerning one of the issues canvassed during the trial, and that is the issue of double nomination. And as you had the court's view, or the judge's view, is that amounts to a pre-election issue, which the election court cannot adjudicate pursuant to the provision in the Constitution, specifically Section 285, that says that only the Federal High Court can adjudicate upon such a matter. So that's where we are now. We have heard from him. We're going to wait to hear from the other justices.
All right. Thank you very much, Professor Amorige. Ezenwa Wango, I'm just talking about the duration. It's a long haul ahead.
Well, we're here. I think today is dedicated to these judgments. Whether it's long or short, we're here. We'll see through it. And I think what's important is that Nigerians are interested in finding out at least some relative closure around this whole litigation and all of that. And since the ball has been set rolling by Justice Samani, I don't think that the other judges will be this lengthy. I think they would either go straight to, because any rehash, if they are going to do the same rehashing which of what Justice Samani has done, then that may be. But I'm sure they are also conscious of time and may not want to take us through this long hog.
Okay, Ezenwa, thank you very much. We are trying to get our correspondent, who is also the head of judicial desk, Dele Atumbi, who is at the court premises and in fact inside the courtroom, but he just stepped out of the courtroom. Once we're able to establish, all right, he's there. Dele, if you can hear me, give us a sense of what has transpired in the courtroom. At least some of the summaries that you have transmitted to us have also been on our screen.
President of the Federal Republic of Nigeria, Kashim Shettima, is a court, and some other governors are here. Opus Odima of Imo State. It is a united unanimous judgment that had been given on this matter, and there are certain things that were equally discussed. One, that the process was an abuse, that the petition itself was an abuse of court process. And for that reason, the court has equally said that nomination of a candidate is and sponsorship is a pre-election matter, and for that the court lacked jurisdiction to entertain the matter, and the matter was dismissed on the ground of lack of jurisdiction on this matter. And don't forget that one of the things that Justice, the lead justice said was that the abuse of court process should not be entertained by the court, and that was one of the reasons that the matter lacked merit, the petition lacked merit, and it was dismissed on the basis of the fact that two things: for lacking the merit and for the fact that the court lacks jurisdiction, because those two issues, sponsorship of a candidate and the qualification, is a pre-election. They are pre-election matters.
Lele, tell us, just before their lordships rose for the interval, there was a question from one amongst the participants. I didn't quite get a name, asking whether this was a unanimous decision or a split decision, and his lordship Samani did respond that the other four brother justices would also read their judgment. We don't have a sense yet whether this is unanimous, or we have to wait until all five justices have delivered their verdicts.
He said it before we left the courtroom that they all concord. It was a concordance of every one of them participating on that panel. It was a concordance. They agreed on that. It was a unanimous judgment, not a split judgment at this point in time. So the issue of APM matter had been dismissed, and the court is functus. It cannot come to it any longer.
That's useful to understand, but of course there are still other aspects of the decision which the court will return to. In a sense, how much more do we have to still hear? But there's the issue of whether a person or a candidate to be declared winner of a presidential election must score 25% of the lawful votes cast in the Federal Capital Territory. That's a matter of the cards, I imagine.
Let me equally say this. The matter came up in the petition which was filed by Peter Obi and the Labour Party. And it would now take the lordships to take a critical look at this issue. And 25% in Abuja, it was Peter Obi that raised it. And in the prayers of Peter Obi is saying that the President of the Federal Republic of Nigeria, President Bola Ahmed Tinubu, did not score 25% in the Federal Capital Territory. Since we cannot dabble into it now, because it is a matter that has not been decided, and I know that immediately they come in, it will be matters to be decided by the justices. 25% in Abuja is a matter that the court will decide now, and we may not be able to dabble into it. Kingsley, you know.
Well, I would just say that it's a matter that is pending in the decision of their lordship. What else should our viewers be interested in what is outstanding with regard to this judgment?
Take a look at the prayers of Atiku Abubakar and the PDP. What they are alleging is that the President of the Federal Republic of Nigeria, at the time of his declaration and return, that he was not qualified to stand in for the election. It's a matter which the court will equally decide, and and I don't want us to dabble into it too much. Atiku Abubakar is equally asking the court in one of his prayers to declare him as President of the Federal Republic of Nigeria. One of his prayers. Another prayer of Atiku Abubakar is for a rerun between him and President Bola Ahmed Tinubu. Whether the court will grant it or not, it is a decision of the court, and it's at the discretion of the court.
What we now know from the decision by His Lordship Samani is that the petition of the APM has been dismissed, and that petition related essentially to the allegation of double nomination. So that's one matter that has been sorted out. Others remain to be decided upon by their lordships, and that will happen when they reconvene. Is that correct?
That's correct, because if you take a look at Section 35 of the Electoral Act, it's talking about double nomination or multiple nomination. And the court, it is now a settled law. It has been settled that the APM matter are pre-election matters. Those things that were brought were pre-election matters, and that it denied the court jurisdiction. And for that matter, for that reason, the court could not double it. It is settled matter. Kingsley, you are right.
Okay, Dele, thank you very much. What we will do is to return to the studio so that we get the benefit of the knowledge of Professor Edoba Omorige for our viewers to have a clearer understanding of the core value of jurisdiction. Because jurisdiction in law, as you very well know, you are a lawyer as well, our correspondent. Thank you very much for what you've been doing. We'll get back to you. I'm sure we'll be able to re-establish contact. And if there is anything, of course, that is happening still in the interval before the lordships reconvene, kindly be back to us, and then we'll open up the lines. Dele Atumbi, thank you very much. Back to the studios here, Professor Edoba. We'll see that the court said, look, this is an abuse. One, it's a pre-election matter, and we don't have jurisdiction. Let our viewers know what might have happened if the Presidential Election Petition Court then opted to assume jurisdiction.
No, they were not in a position to assume jurisdiction because, like I said, the Constitution is clear on matters like this, and I think that's what they pronounced. Section 285 is the relevant section, and that section says that if there's any concern about nomination, in fact, it was in 2018 that alteration was made there, defining what constitutes pre-election. Hitherto, it was not very clear. So that if there is any concern about nomination of candidate of a political party, the Constitution requires that such a challenge should be taken up within 14 days upon becoming aware of that situation, and that is before election. I think that's what the court has virtually has pronounced upon, meaning that the issue of whether the vice president was nominated previously for Senate and subsequently tapped for vice president, presidential candidate, constitute matters before election, which ought to have been litigated before the election of February 25. And so I think the court has, virtually just restated what, the courts have decided upon frequently on this issue. So jurisdictional issues are very important because a court without jurisdiction cannot adjudicate upon a matter. So it's a threshold issue. It's only when the court has been conferred jurisdiction that you can assume it and decide on the substance of the matter. So the substance of the issue has not been addressed at all. What was addressed is whether this tribunal has jurisdiction. The proper court in the Constitution and even in the Electoral Act is the Federal High Court. And that's what the court has said.
Okay, Prof, thank you very much. Ezenwa, the question of challenging the eligibility of a candidate in an election, how onerous is this a duty on the part of anyone who seeks to mount such a challenge?
Well, I don't think there's a big challenge from that. The way the processes are structured is that we do know that INEC publishes qualifications of the different candidates who will be running in different political parties, and that's public knowledge. So even if you couldn't avail yourself the opportunity when that publication was made. You can go by way of seeking the CTC, the certified true copy, which INEC is obligated to give to those who apply within a stipulated period of time. So I don't, if there is the interest to pursue that in terms of qualification. But what I see often is that many litigants test water because if by simply listening to this judgment, there is some kind of irritation in the voice of the justice in terms of why are you bringing this? This is something you should ordinarily know. But as it is, Prof has told you, you can't assume what you don't have. So, and I think that the lawyers who also test these waters want to see whether it is possible to technicalize the conversation and see whether there is a loophole. And that is okay. It's also part of what it is. But simply, the task is very simple. Once people apply for a position, they apply with their qualifications. In the Constitution, it's very clear. You have your age, the educational qualification is also a constitutional matter. Your state of origin, your Nigerianness, and those issues. You put it out there. And then, so have you gone to jail before? Have you been convicted? And all of those things. If you answer those questions, you put it out there. And what needs to happen is that as we continue to develop, those things can be put on the website of INEC so that people can simply download it without necessarily going through all this CTC. Because as we advance in technology, we should also advance in such a way that makes these things more difficult. We run an adversarial regime of judiciary where people have to be, you have to be the one proving, not the other way around. If the man has been cleared to contest, you who want to unseat him must do the duty. But the Electoral Management Body has to create what we call level playing ground for everyone who wants to be able to access information to do that. And that can be done through their website. And I think that's the way they've been trying to go.
But in the public space, for a pretty long time, ahead of the 2023 elections, the structural issues around the elections, of course, had to do, one, with amendments to the Constitution, and secondly, the enactment of the Electoral Act. It took quite a while. The Electoral Act eventually was passed, and then we had the Electoral Act 2022. We know that there have been several petitions handled by tribunals with respect to either governorship or legislative elections. But this again, what we are having today is the big one. Many would say is the big elephant that everyone is focused on. Is there a sense in which, based on the experiences from the previous decisions by the other tribunals and what their lordships are now deciding on today, that this will be like a true test, if not trial, of the relevant amendments to the Constitution and the operationalization of the Electoral Act 2022?
Yes, of course, that's what we are seeing now, which is that some aspects of the Constitution that seem to be unclear. You know, again, they are being clarified again. You know, although, like I said, some of these things, because the aspect that relates to pre-election, it's not new. It's been on now since 2018, and there are many judgments on the point. Perhaps the only one that seems to be unclear is the provision of Section 134 of the Electoral Act, which now try to incorporate qualifying and disqualifying provisions contained in the Constitution, you know, as grounds for election petition. So to that extent, we have not had that before. So with that introduction of qualifying and disqualifying grounds as grounds for election petition, some persons will feel able to raise issues even post-election that would otherwise be classified as pre-election. So what this court has done now is to reaffirm the position that despite that, you know, incorporation of qualifying and disqualifying grounds of the Constitution into the Electoral Act, the position taken previously by the courts as to what constitutes pre-election, as disclosed in Section 285 of the Constitution, remains the case. So that even if you go to court and say, well, you are not qualified, you are disqualified as an election petition ground, you would have to contend with the question. These questions of quality, you cannot raise them as an election petition question. You would still have to meet with the challenge that you ought to have raised them, not in the election petition court, but in the Federal High Court, as provided in the Electoral Act. So that is the position. So to answer you, the novel position now, which the court has pronounced, as far as the first arm of the challenge, is that the jurisprudence of pre-election remains. Namely, any matter which relates to matters before election remains pre-election matters. So that you can raise them as election petition matters.
Well, the Electoral Act is its first bad day was on the 25th of February, the very day that election took place. That was the first 1 year of using that Electoral Act. So it's a baby in terms of operationalization. But one beautiful thing about elections is that Kinsley, the work that you did to get that thing passed, that helps us to have better elections than we used to have in the past. And so when people, and I listened very attentively to Justice Samani when he was talking about nobody can import what does not, you can't bring in something that does not exist. They are not going to give you all of that. So I'm excited that we are seeing some kind of a legal framework that helps us to drive our electoral process. But it has to be tested over a period of time. And part of the test is what the court is doing. The court is helping us to unpack the Electoral Act, make it simpler, because the mysticism of legal terms and all the rest, when this judgment comes, we are then able to see whether what we pushed has helped us to advance our elections in the direction we wanted it to go, and then we can begin to x-ray all of that. But it's still morning in terms of where at least one part of it has been closed. We are eagerly waiting to see other issues. But I think the issue of qualification has been closed in terms of where should you go to if you have issues around qualification or disqualification, and
where should you go to and when?
And when you should go there. Those have been cleared in terms of if we can't do that at this place. What we do is to look at the conduct of these elections and how it followed the Electoral Act. If you have other issues, take it to some other. And I think it should be a learning, because all of this is not just the excitement of winning or losing. It should be a learning for both the political parties, the electoral management body, and other stakeholders in the electoral process to just say, what are we taking? What are the lessons away from all of this? What advocacy issues are all of this throwing up for us in terms of even making our elections better? And that for me is the crux of today's engagement. Is a learning curve for us. We are consolidating our democracy, and the only way to do that is to keep improving, keep getting better. And I think that is what all of this. And then special thanks to putting that out on live television. If you whatever you want to take away from it, that opportunity has been given to us, and it's something we shouldn't take for granted.
Thank you very much. One other very interesting aspect to all of this, Prof, this question is coming to you. Because early on, before the court began reading its decision, Ezenwa, in responding to one of the questions, did say that, yes, today is a big day because it's leading us to closure. But we know, as he also indicated, that this is the first step. But significantly, the timelines are delimited.
Yes.
What are the uses of this versus